competent in that field. Don, do you know the topic you're going to deal with?
Yes.
Because they've all changed the topics on me, as you can see. Doug Goudie has a tennis lesson at, what is it, 6 o'clock, Doug? So we'll try to accommodate him.
Mr. Papazian knows that I tend to be long-winded. That's his comment to me, I'm sure. On the notes, which is Section E of your book, the yellow sheet indicates solicitor's professional liability insurance claims made policy, and I can assure you that's not the topic of my discussion. What I did on the first page, E1, was to set out certain provisions of the present solicitor's errors and omissions policy, which refers to the topics of notice, action against the insurer by the person insured. And I set those out so I could use them as illustrations. The yellow sheet got typed up by my secretary when I wasn't in the office, and I think the law society phoned her up and said, what would Mr. Lapowich call this topic? So she wanted to excite everybody, and she knew lawyers are very interested in liability policies that affect them, and that's how that came about. But really what I'm going to talk about is the requirement of notice to the insurer of a claim, circumstances, whatever the wording of the policy is. Secondly, if there's a breach of the condition of the policy, the provisions for relief from forfeiture, that the court can give relief to the insured. Thirdly, if we have enough time, the proof of loss, which is the formal claim put forward to the insurer. Next, the action by the person insured against the insurer. What rights and when do they have the right to sue? And lastly, what about a third-party judgment creditor, the person suing the insured who gets a judgment and then tries to enforce it against the insurance company directly? With respect to notice, obviously policies of liability require notice to be given to the insurance company, or notice of a happening or an event which might give rise to a claim. Normally the notice has to be in writing, of course, and in all instances it should be given in writing so that the insured has some evidence that he gave his report. The wording varies from as soon as practicable, forthwith, promptly, as soon as reasonable, etc., etc. And insurers will look to the timing of a notice to determine whether they have been prejudiced. So it's extremely important for the insured to give his notice as soon as possible. Notice is also a conditioned precedent in most policies before you can recover indemnification from your insurer. Now, what I propose to do is illustrate two notice provisions. Most liability policies will have one notice provision in the sense that the policy that was in existence when the act complained of occurred is the policy that responds. So if it was a problem of liability 2 years ago, when your client is sued, they go back to the policy which was enforced at the date of the occurrence. Professional liability policies, however, a number of them, are on a claims-made basis. And that means that the policy in force when a claim is made against the insured is the policy that will respond. The importance of that is this. If it's a claims-made policy and you do not report under the policy in which you became aware that was in force, it's free and clear. At the end of that policy, you change your carrier and you go to another insurer, that policy is free and clear. The policy which is in force and effect when a claim is made will have a provision that if you were aware of a happening or a claim before it became effective, it doesn't apply. You should have reported to the other policy. So that type of notice is extremely important because it's crucial. It's a matter of coverage or no coverage. Then the claims-made policy will also have a provision that you have to give notice of a claim or a happening as soon as practicable. That recognizes that the policy is in force, but you need a timely notice so that the insurer can open its file, investigate, decide whether it wants to defend or not. And the question that's asked, the important question is, how do you determine when the insured has to give notice? And a case which is up in limbo now because it's subject to appeal in the paper is Craig, Zeidler, and Strong versus Simcoe and Erie. And it's an architect's insurer's case, an architect having a professional liability policy. The policy was a claims-made basis. When the writ came in, there was a new policy that had been renewed just prior. The circumstances of the events happened under an old policy. And of interest is the fact that the new insurance company from which the architect was looking at had a renewal with an increase in coverage from $250,000 to $500,000 the very year that the claim was reported. So in a certain way, one can understand why the insurance company was a bit hesitant and was looking very carefully into the matter of notice. The first aspect was when the insured renewed the policy, and in effect the court treated it as a brand new policy in 1973, he was asked whether they were aware of any circumstances which might result in a claim. Is the firm aware of any error, omission, negligent act, unresolved job dispute, etc.? The key there is the word aware. Sometimes they use the word knowledge. Did the insured have knowledge of a claim, a happening, an error, or act? Now remember, if the insured did have knowledge, when the new policy when there was a new renewal in January 73, ball game over. The new policy would not apply at all. And there was no report under the prior policy. Now, Mr. Justice Keith decided this case, and unequivocally, he determined in his judgment that the insured himself must be aware of a happening or a claim. A purely subjective case. He said that the making of the decision to report a claim to an insurance company lies on the person who is insured, and when he feels the matter has gotten to the point that he should report to his insurance company. The trial judge made a finding that the architects had no knowledge of a prior omission or act when the policy under which they were suing for indemnity came into force and effect. Unfortunately, that decision, or fortunately, depending on which side of the case you're on, has been appealed and the action has been ordered to be retried by reason of the judge's alleged bias towards the parties. And the Court of Appeal refused to make a finding at that time. They said it was inappropriate to decide whether the knowledge of the insured to report had to be objective. In other words, you asked, would a reasonable architect get a letter from his client, the Peterborough County Board of Education, saying there's leakage all over the place? Would a reasonable architect have to report at that time? Or would the insured himself have to report only when he thought that it had got serious enough that he might report the claim? In those instances, most of the times you have usually a conflict between the contractor and the architect in any event. And the architect will say, well, the building contractor did a job sloppy, he didn't follow the specs, etc. And the plaintiff will use a shotgun effect and say the design was improper, improper supervision by the architect of the contractor. That subjective test was used in a further case called Stevenson that I've indicated. Again, it was an architect's case, and the reason I picked architect's case because everybody picks on lawyers, so I figure I would pick on another profession. And the architects did not report this matter at a time when they received a letter from the Department of Public Works alleging improper quality control and site supervision of the construction of a penitentiary. And the court reviewed the facts, and they held that you are to give notice as soon as practical. That was the wording. And they held again it was a subjective case. And the way they did that, they made a finding which said the letter was an expression of dissatisfaction, falling short of legal pursuit. Obviously, it's a judgment choice. It depends on the court. But I want to read to you what I think is the key factor in these decisions. They're not legal factors, but I think they're the key factors in all these decisions on deciding whether the notice given is timely, is objective or subjective. The court in the Stevenson case said there is no doubt on the evidence that the members of the insured firm honestly believed that there were no circumstances that would give rise to a possible claim against it. Now, I would submit to you that if the court makes that finding a fact, you don't have to worry whether the test is objective or subjective. Even Mr. Justice Keith, when he used the subjective test, made a statement. The person who signs the application must ask himself, and no one else, are my answers to the best of my knowledge true and not distorted, etc. This is a subjective test, albeit that one must respond to it as a reasonable man. So it's very difficult really to say that in some instances the subjective test is not objective. In the Scholler case, which I've indicated in the notes, there was a late report and there was a true objective test in that situation. The facts were, however, that one of the plaintiff's trucks attended a plant of a third party and allegedly rolled over some pipes and damaged them. Well, the driver came back to the plant and he denied that he caused any damage, and the officer of the plaintiff company went to the site the next day, and he determined in his own mind that there was no way that the owner of the plant was ever going to be able to prove that the plaintiff's truck caused the damage. So there was no report made to the insurance company, and there was a report made many months later when the insurance company for the owner of the plant, which was subrogating, wrote a letter of demand. And in that instance, the court held that an ordinary, prudent insured acting reasonably would consider that he had notice of a potential claim or circumstances which might give rise to a claim. The facts, I think, speak for themselves. Now, once you determine, or the insurer determines, that there has been a breach of the notice provisions, what do you as a solicitor do to try and assist your insured to collect under the policy? In the lecture, you will see reference to Section 106 of the Ontario Insurance Act. And that's what we call the relief from forfeiture section. And it indicates that if there has been imperfect compliance with a statutory condition in a policy, or as to proof of loss, or other matter or thing, the court can use equity and prevent a forfeiture or avoidance. And of course, that provision would come up if an insured has given a late notice, because in effect, the insurer would be saying, you breached a condition of the policy. And the courts have held, although the use of the word is statutory condition, as to proof of loss, or other matter or thing, that it will apply as well to a purely contractual condition in a policy. For example, the Minto Construction Limited case was a policy involving a general liability policy. And there is not in the Insurance Act a statutory condition applicable to a general liability policy. However, the court determined on this basis, we should interpret the relief section very liberally and very broad. And if we decide that you can get relief from forfeiture because you breached a statutory condition requiring notice, for example, in the fire policy, and you cannot get relief from a contractual provision which the insurance company and the insureds have agreed to, you're putting the contractual condition on a higher plane than that which the legislature has permitted relief for. So they have unequivocally come to the conclusion that the section, notwithstanding the way it's worded, will apply in a policy which has a strict contractual condition requiring notice. And in the right circumstances, you will get relief from forfeiture. What is the test for relief from forfeiture? To sum up, I think basically it's a relief from forfeiture will be given if the insurer has not been prejudiced. And again, it depends strictly on the facts of the case. It's a judgment call again whether the insurer has been prejudiced or not. For example, I give to you the key, I think, to the Minto case in this statement of the court. If the insurer and its solicitor had been involved from the beginning, i.e. by early notice, there is no suggestion that they would have achieved any happier result than the insured. Because in that case, when there was a denial because of late reporting, the insured went in and settled for a certain amount. I find that as the key to the case, despite the wording of the judgment itself. One of the leading cases for Ontario is Canadian Equipment Sales and Service Limited. And here's another wrinkle where the insurer denied coverage, first by saying that the policy did not cover the situation, and secondly, there was a late report. And the question was whether relief from forfeiture would be granted because there was late notice given by the insured. And it was a situation where the plaintiff was retained to connect a new water pipeline to an existing one. And it was a line that went into the Dow chemical plant. And of course, the water for circulation for chemical processes was extremely important. And they did it by a process called a hot tap, which basically I understand is you cut away a portion of the existing water pipe and make grooves in it, and you fit the new water pipe over it, and you've got your connection. The piece that drops off, that you cut off, is called a coupon. And a coupon here, instead of being extracted, fell into the existing pipeline. Now, the loss was the time and expense trying to find this coupon, because they were afraid that if it ever went down the water pipeline and got into the plant itself, it would be a tremendous claim. And the insurer decided under a liability policy that this matter was not covered as not being property damage or loss. And for good measure, they threw in the fact that there had been a late notice, and there was a late notice. And the decision by the court was that the insurer has repudiated the coverage. Where the insurer makes a decision that there is no coverage at all, relief from forfeiture for notice provisions will be given, and the insurer is not prejudiced. How can they be prejudiced? The statement is this, again, based on the facts. The insurer here would merely have decided months earlier that the policy did not cover the occurrence. That was the reasoning of the court. And the ratio, however, was that the relief from forfeiture section depends on whether there is clearly actual proven prejudice to the insurer by reason of the late report. The West Coast Securities Limited case also follows on the basis of repudiation and holds for the same principle. If the insurance company denies liability and repudiates the policy, then in that case they were complaining about the fact that a proof of loss was not filed in a timely manner. and the court immediately gave relief from forfeiture. The insurer could not rely on the failure to file a proof of loss in another case reported in the notes because it denied liability. And that's extremely clear. But remember that there's a difference between the insurer denying liability and saying the policy does not apply, as against the insurer saying the policy would apply to this claim except that you were late in notice and we were prejudiced. Only in the first instance is it easier to have the court determine that there's relief from forfeiture. Some interesting instances where relief for forfeiture was sought, I've cited in the notes, and I only put them in for interest's sake because it's surprising how far insureds and people will go, or insurance companies will go for that matter, to try and resist a claim. One was a situation where the plaintiff insured under a motor vehicle policy, and this is in Saskatchewan, by the way, did not deliver a proof of loss in a timely manner because he was misled by his insurance agent. The agent said, look, we'll have to wait until the court determines, makes a result of your impaired driving charge before we can consider whether you have any insurance at all. The insurer was not allowed, obviously, to rely on the provision in the policy. On the other hand, an insurer tried to get relief from forfeiture when it had failed to pay the insurance premium, so that policy was not enforced. And you can determine that the court wouldn't go that far. Another interesting example is where a plaintiff was in breach of a notice provision for a 6-month delay period. The insurer was notified, and the action was going on against the insured, and the insurer waited for 1.5 years before it then decided and gave notice that the policy didn't cover, and secondly, you gave a late report to begin with. And the court said that any prejudice was by reason of the fact that the insurer waited a 1.5-year period, and they determined their own loss, and that was the end of that. Another instance is where there has been total non-compliance with a condition, and in this case, under a fire insurance policy, a proof of loss was required. I think I should point out in a lot of these cases, such as this fire insurance one, the court made a determination that the insured was responsible for setting the fire. Then they said the failure to file a proof of loss for him for 3.5 years was non-compliance, and there is no relief from forfeiture for total non-compliance. Well, that gives you a smattering of cases on notice and relief from forfeiture. Presuming that you have given timely notice or you can get relief for forfeiture, your insured must then present its claim to the insurance company. And the way it presents its claim to the insurance company is through what we call a proof of loss. And a proof of loss is a sworn statement. It's a declaration by the insured, number one, how the loss took place. He has to prove that it fell within the terms of the policy. If it's a fire policy, it was a fire. If it's a liability policy, you're being sued for liability, whatever. And secondly, he has to prove the quantum of his own loss. And the proof of loss are extremely important. And a number of times, proof of losses are just generally thrown in without any real consideration as to what should go into it. And the insurer will look at that proof of loss and very carefully will scrutinize it, because if there's any exaggeration, and in some cases it's just any exaggeration, they will take a position that the claim is vitiated. I've referred to the case of Fotinos on this subject, where there was a fire at the plaintiff's leather goods plant, and there were two proofs put in because there was a policy covering the building and separately, and I don't know why it wasn't a comprehensive policy, a policy covering damage to equipment, fixtures, and business interruption. In this case, again, by the way, the court found that there was arson committed by the insured, but they also found discrepancies in the proof of loss. there was a non-disclosure that the insured individual had a lien on his sewing machines. I guess the insured thought if he revealed this, the insurer might find out that he was in a bad way. He was encumbered and owed a lot of money. And secondly, he claimed $500 to replace some bathroom fixtures in the plant. It was found that they could have easily been cleaned. And then thirdly, which is more telling, he produced false financial statements to show that he made a profit of $26,000 during a certain period. As it turned out, he made a loss of $20,000. But I want to point out, the other factors are obviously important, but I want to point out the dicta of the court. And the court was talking now about the $500 claim for the bathroom fixtures. And it was being argued that this claim was embellished because you merely had to clean them. The court said that they found that the fraud of $500 occurs no matter how slight the amount of the claim. And that being so, the entire claim, and I stress, the entire claim under the proof of loss was forfeited. In another case, Lazy K&T Cattle, there was a claim for destruction of a building, a house, and the contents of a home. In that instance, the contents had been saved to a great degree, and notwithstanding, there was a fraudulent claim, an excessive claim which bordered on fraud. There was also a defense that the claim for the loss of the building was grossly exaggerated, and the court held that they would not find that the claim against the house for its loss was grossly exaggerated. And then said it doesn't matter. Because once we proved that the context claim was embellished or fraudulent, your entire claim, even though you were honest with respect to your building loss, is gone by the board. Another instance of a difficulty with a proof of loss is Swan Hills Emporium. And then in this instance, it was a business which had suffered a fire loss. And one of the officers included 3 television sets as part of its stock and trade. And as it turned out, they were not destroyed in the fire. And as it turned out, the trial judge felt there was no fraudulent intent. And as it turns out, the Court of Appeal said this is ridiculous because the company's officer knew that they weren't destroyed. He put them into the proof of loss. He was obviously making a claim. Now, the claimant's counsel was extremely sharp, I think, and immediately shot back to the judge the proposition that it doesn't matter. The contents claim, aside from the 3 television sets, greatly exceeded the limits of the coverage. So why worry about 3 TV sets? Because if you take them out, the rest of the claim is still beyond the coverage. But it didn't work. The court held that that is a willfully false statement, and we will vitiate your further claim. And further, you can't go back to Section 106, which allows relief from forfeiture, because you aren't inadvertent, you're not imperfect, you're not non-compliance. You are deliberately misleading or deliberately embellishing. One of the cases reported in the notes, I'm not going to go over it, is one probably dear to all our hearts. The way the insurer tried to get around the fraudulent or embellished proof of loss, using a nicer word, was to say that his lawyer was inexperienced. And his lawyer looked at the proof and told him what to put in, and that was it. And I'll tell you, the court said that if it was by reason of the lawyer's inexperience, and they were concerned about this, they would have given relief due to the fact that some things had been put in the proof that shouldn't have. But happily, they came to the decision that it was a willfully false proof of loss, and the lawyer was not so inexperienced, and that was the end of that one. Now, briefly, Section 106, this relief from forfeiture, has been held unanimously on the higher courts not to relieve you, or not able to be pleaded, when you do not issue a writ in time, where there's a limitation period, whether it's statutory by the Insurance Act, 1 year to sue under the fire insurance policy, or contractual under boiler machinery policy, which by contract, some of them say you have 14 months to sue the insurer. In any instance, you cannot use relief from forfeiture to extend the limitation period. And they go back to the old theory, I guess, that we all learned in law school, and I still don't understand, that a statutory limitation period, if you exceed the statutory limitation period, you still have the right, but you can't enforce the remedy. And that is not an avoidance. There's a distinction. And I'll say no more about that. The importance of filing the proof of loss and filing it in a timely manner is illustrated in one of the cases. The provisions of the policy, a lot of them will say you have to file the proof of loss and that the insurance company then has 60 days within which to pay. And you then bring your action 61 days or 62 days after if they don't pay. The proof of loss in the Ferries Enterprise Limited case was filed within a timely period, although not within, I think it was about 5 or 6 months. The writ was issued before the year was up, and at that point, the insured who was suing demanded an appraisal because there was a dispute as to value of the goods that were lost. And the Insurance Act, under the fire insurance provisions, permits the insurance company to appoint an appraiser, and the insured appoints appraiser, etc., and you have an appraisal. Well, the action was started in September of 1979. The appraisal took place, and the decision on the appraisal came down on October 6, 1981, 2 years later. The court gave judgment to the insured, it had a good claim, and it awarded prejudgment interest. And it awarded the interest from the time 60 days after the proof of loss had been filed back in 1979, notwithstanding that the insurance company didn't have a determination by the appraisal until 1981. One point I want to mention I think is important because I have had inquiries in this regard. Let's say you get involved late on in the situation and no proof of loss has been filed, and it's under a fire insurance policy or some other policy, and the statutory or contractual limitation period is coming near. The fire insurance provisions, for example, require an action to be instituted within 12 months. There's another condition which says that the insurance company only has to pay 60 days after filing proof of loss. Let's say you filed the proof of loss very late on in the game. Do you wait 60 days, even though if you do wait, the 1 year will be up? Unhesitatingly, do not wait. Issue your writ. The only case that I've been able to find in obiter dicta is Roe versus ICBC, which I've cited in the note, which the court held that the determination of the commencement and termination date of the insurance limitation period does not rely on when you file the proof of loss. The limitation period relies on the date of the occurrence or when the cause of action arose. How are we going? Want to speed it up? Okay. Let's go on to another topic, and that is the insurance company's obligation to defend. You will recognize in a third-party liability policy that there are two types of coverage. One is to indemnify the insured person against a liability for which judgment is given against him by a third party. The second obligation is that the insurance company must also provide a defense. And where the insurance company would rely on, for example, a breach of a notice condition or some other breaches which did not go to an actual repudiation of the entire policy, the International Form Tubes case was a leading case in Ontario, and it said that the insured could not sue the insurer until there was a judgment against the insured, or until the parties, including the insurer, agreed as to how much the liability was to be. This is based on what we call a no-action clause. And on page E1, I've put in the no-action clause for the solicitor's errors and omissions liability. But basically it says if you want to sue your own insurance company, you have to comply with all the notice provisions, etc. And also you have to wait till you suffer a judgment, etc. And you cannot, when you're sued, third party the insurance company in that instance. The Great West Steel case says we will uphold the no-action clause. We will not allow the insured to sue its own insurer until there's a judgment. But the insured, while that action is going on, can sue for a declaration that the insurance company owed him a defense and they were not giving it to him. Then we come to a situation in British Columbia where the court pointed out, and this is Svechtlini case, that there is a no-action clause to which the court must give credence, and it is a serious consideration, and the court will make it a significant factor in deciding whether they will allow the insured to third party their own insurance company when they are being sued by a third party injured person. But the court said, you know, this really conflicts with the rules that the courts go by, that we have third-party proceedings so as to avoid multiplicity of proceedings and potential inconsistent results. And in this case, they said that the issues were significant enough in both the main action and the third-party action that they washed out the no-action clause. They permitted the third-party action against the liability insurer to proceed. You'll also be interested in knowing that this case was an action against a solicitor, and it was the solicitor who was bringing in his own insurance company in British Columbia because he felt that he should have coverage and he should be defended. In that light, I want to point out one further provision of the Insurance Act, which is an important one, and which is now in the courts, is Section 109 of the Insurance Act. Most of you will be aware, of course, that if you have a motor vehicle liability policy, as was indicated before, no matter how negligent or remiss is the insured under his own policy, and he has breached the policy, the third party who is injured is protected by statute, by the courts, under what we call the absolute liability section, where the motor vehicle insurer will have to pay the innocent third party who's injured on the road. There is an equivalent section, which is Section 109 of the Insurance Act, and it applies to a general liability policy. It is not a section that applies to automobile or fire. I forget the actual provisions, Doug. It's fire, automobile, and accident and sickness, I believe. But it applies to everything else. And it says that if a person obtains a judgment for injury or damage to his person or property, and the person who they sued does not satisfy it, and there's an execution return nulla bona, then you can go directly after that person's insurance company. Very similar to the automobile. The rider, however, is that the insurance company can raise any equity it would have had if its own insured sued, i.e., breach of notice conditions, failure to cooperate, etc., whatever it might be. There are currently two divergent cases. One is Perry versus General Security Insurance Company of Canada. It's an Ontario case by Mr. Justice R.E. Holland, which is now before the Court of Appeal. They've reserved decision. It involves a solicitor's error and omissions policy. It involves a case in which a solicitor was sued and did not give prompt notice at that time to Maltmans, did not allegedly cooperate in a proper manner. There was a judgment against the solicitor, and the person who obtained the judgment, the innocent client, and they were referred to as an innocent client, sued the errors and omissions insurer that was in force in effect back at that time when the claim was made. And Mr. Justice Holland said, although Section 109 is remedial, etc., an errors and omissions policy is based on breach of contract or negligence by a lawyer. It's a professional liability policy, and it's not where a person is injured in his person or his property, like a liability policy. And he refused to apply the provision. And he refused to allow the client, who now had judgment, to bring an action directly against the errors and omissions insurer. He put a rider on it, however, and said, I would suggest that the legislature might see fit to amend the Insurance Act. Well, it might be the courts that amend the Insurance Act or give a different interpretation, because in Saskatchewan, a case called Callis versus Saskatchewan Government Insurance, almost on the exact same facts, in the sense that it was a lawyer's errors and omissions policy. It was a lawyer who allegedly did not cooperate, was in breach of the policy, etc. There was a judgment given. The court refused to follow the Perry case entirely, and they simply came to the conclusion that the equivalent section in Saskatchewan was obviously meant to relieve the situation where an innocent client could not recover from the erring solicitor through no fault of themselves. So in that case, the court interpreted it as if the legislature had already legislated what Mr. Justice Holland had invited them to do in Ontario. Thank you very much for your attention.
Thank you very, very much, Don.